Good afternoon, members of the committee. My name is Teresa Lancaster. I'm an attorney, I'm a survivor, and I'm an advocate for those abused sexually. I was abused in 1970 through 1972 at Archbishop Keough High School by Father Maskell. I was featured in the documentary The Keepers, which exposed a huge sex ring at Archbishop Keough High School. I was unable to come forward about my abuse in the 70s because Father Maskell convinced me that no one would believe me, and he threatened me with his gun. Almost on every session, he would have the gun out on the table. I feared for my life. This is common among survivors. The support group RAIN supports that 20% of survivors fear retaliation. That is a reason for not coming forward. I struggled with the fact the abuser was one that I trusted, and he had respect of the entire community. Survivors typically take years to come forward. The severe nature of the trauma endured, coupled with high social positions often held by the abusers, prevent survivors from coming forward earlier. Other facts are depression and substance abuse. Studies show the average age of disclosure is 52, and the reasons for the delay are specific to the individual. In 1994, when Jean and I came forward and started our civil suit, we quickly realized the institution we held our trust in would again betray us. Cardinal Keeler knew their case was credible, but he used the statute of limitations to make our case go away. Betrayal of a trusted institution adds another difficult layer onto the trauma of abuse. For these reasons, I urge the committee to issue a favorable report for House Bill 974. Thank you.
Good afternoon. My name is Jennifer Gross. I stand before you or sit before you, a parent, a sister, a clinical social worker, a certified sex offender treatment provider, mother of 2 Boy Scouts, former diocesan coordinator of safe environments, former chair of a regional review board for the Catholic Church to review reports of clergy abuse. I am here today not to talk to you about what child sexual abuse does to the victims. You've heard that already. But to stress to you that when a child is sexually abused by one person, it's devastating. That is one person that views them as trash and not as a human being worthy of dignity and respect. Far worse then is when an entire institution turns on that victim. For now it is not one person treating them with a lack of respect. Now it is hundreds. This bill before you today is not against any one institution. As previously testified by another committee member, Catholics, as far as we know, have committed only about 4% of all abuse. Shame on my church. Shame on my church for being the leading opponent to this. Shame on them. I am the direct descendant of Archbishop William Gross, who was first ordained in Baltimore. I will tell you, as a certified sex offender treatment provider who has worked in the field for 26 years, I only worked in clinical agencies that polygraphed offenders. In 18 years, I met one person. They had one. The majority of offenders had many, some up over 900. Sitting on a regional review board of clergy offenders, I once heard of a man who sexually abused a 4-year-old boy, his 13-year-old niece, and raped an old woman in a coma. Where is that man now? Mexico. Why? Because apparently the church finds the United States rapidly anti-redemptive. How can I still call myself a Catholic? Because this is my church too. And I will not allow it to only be represented by people who defend the indefensible. I am here before you to ask you today to protect my children. Raise your hand if you leave your children with know will hurt you. No one. Don't do that to my children. Open this door of justice for survivors. Open this door of justice for survivors, which in turn provides safety to our children for today. Eliminating the statute of limitation exposes predators we did not know are still among us and are a danger. Please open this door to justice and protect my children, your children, and all our children.
Hello, my name is David Chappelle. I'm from Ellicott City. I've been married for 17 years and we have 5 children. Our 2 sons are 13 and 11 and our daughters are 9, 7, and 2. We attend Mass every Sunday at St. Louis and Clark, raising our family in the Catholic Church. I'm here today to testify in support of HB 974, which will help countless others to receive justice in court. I am proof that repressed memory is a real thing. My goal is to advocate for those who have not yet recalled their abuse. I'm 42. In last April 2019, called my abuse that happened when I was 9 years old in 1986. My mind or body or God wasn't ready for me to re-experience the trauma until then. My recall process was slow, in months to fully crystallize. I was extremely painful and debilitating. I was a shell of a person. I write down all my memories in this book through my therapy. This book is filled with awful memories from a lost childhood. I thought of suicide numerous times over the last year. It's only because of my therapist, my medications, and the tremendous love and support from my family that I'm here today. I've been diagnosed with chronic post-traumatic stress disorder, and I'm so fortunate that my employer understanding of my needs as a person with a disability. Yes, I do now have a disability. Therapy has cost us over $10,000 in this 1 year alone, a huge financial strain. My abuser was Father Wehner Brown. He pled guilty and was convicted in 2018 to child abuse and rape 2 boys in 1987 and 1988 in Savannah, Georgia. In fact, the only reason that they could try him in 2018 was because some of the crimes occurred in South Carolina, which has no statute of limitations to bar prosecution. Father Brown sexually abused me in 1986 in Gaithersburg, Maryland at St. Rose of Lima Parish. He was at St. Luke's Institute for Rehabilitation relating to prior sexual abuse allegations. He was allowed to volunteer in my CCD classes and attended church events. He was playful, charismatic, with a friendly smile. But looking back, he was sick and sinister. He used God as a way to prey on children. Our entire community had blind faith in this man because he was a priest and he abused that privilege. Father Brown taught me special ways to pray to God, special sacraments to consume, and there was even a way you could speak to God directly by putting your mouth on a certain male private. I was 9 years old being abused by a priest, but to me at the time, it was a special form of. One time, Father Brown even threatened me with a gun. I asked, "Why do you have a gun?" He said, "So I can be sure that I won't tell anybody about what was about to happen." That's when he sodomized. I blacked out from the pain, but when I woke up, he had me say the Hail Mary prayer. I could barely speak. Later that same day, he asked me to leave with him to go to Georgia. But he had to leave soon. I said, "No, family just moved here. I can't go with you." It sickens me to think now what happened in the next months, years in Georgia and South Carolina. He did not take me to Georgia, but he took so much of my innocence. He introduced me also to another priest who also sexually abused me in 1986. He remains in ministry to this day in Massachusetts. After a time of transition at St. Rose, a new priest, Father Duggan, was assigned to our parish, and I told him about what had happened. He did nothing. I was never abused again sexually, but my mental abuse continued when nothing happened. My brain went into survival mode, and in order to operate and function as a normal teenager and adult, my brain had to suppress the trauma that I experienced. This is my sworn testimony under oath. There are many more stories to be told. For all those who have been abused, who haven't called their abuse yet, I urge you to support HB 974. This abuse was an attack on my faith, my body, my soul, and my mind. Allowing myself to remember and relive these events had a catastrophic event on my life and my family. However, I am a survivor, and I am starting to heal. For some survivors of abuse, part of our healing process is to receive justice in court. We deserve this opportunity because our memories are very real, regardless of when they decide to serve. Thank you.
Good afternoon. My name is Paul Ruffin. I'm the legal director of Child Justice. I have my organization. We are here in support of this bill and for a favorable report. We've heard so much powerful testimony. Those is the wrong. So many people are still feeling the lack of justice that they're facing right now. We do urge this passage. And the topic of forgiveness it's a very interesting topic. It's a very strong, powerful issue, but it's really an individual issue. Not something to stick. And it's up to the individual to decide what they wish to do. And with my own faith, forgiveness is absolutely urged, but also as atonement. The one must atone for their sins. So have forgiveness, but still have the person be held responsible. I point to the Terry Anderson case where he did forgive his captor, but he also sued them. The judge of $26 million. So I need to keep that in mind that while he was into forgiveness, he also was responsible for their act. So again, we urge support of this bill.
Hi, I'm Kathy Myers. I'm the director of the Center for Children in Charles County, Maryland, and I've been in the field of child abuse, both victims and offenders, for about 35 years. I'm going to talk to you from the perspective of offender. If I'm a sex offender, I groom you. I make sure that you trust me completely. I make sure I groom, if I'm a sex offender, everybody around you, so that if you happen to spill the beans on me, they will not believe it. If I'm a sex offender, I make sure that you think it's your fault. If I'm a sex offender, I make sure that all of the systems where I work will protect you as well. I make sure if I'm a sex offender that if I'm caught, you'll allow me to resign without you firing me for a clause that would be in my record. If I'm a sex offender, I put in this wonderful evaluation if I do get caught by the people that you pay to evaluate me, what a wonderful person I am and how I couldn't possibly have done this. If I'm a sex offender, I know what I'm doing. I pick my victims very carefully, and I go to places and institutions where I have access to lots of children who, if they tell on me, will not be believed, will be covered up, will be dismissed, and I will be protected. That's if I'm a sex offender. I know that I'm speaking to people in this room who have not come forward, probably about 10 to 15 just based on the numbers, and there's people on this panel who are in those same shoes as well. Please protect our victims, because about 5% of cases are prosecuted criminally, and of the 5% that are prosecuted, or 5% of victims come forward to authorities as kids, and about 7% of those cases prosecution. So that is not the remedy for the victims that we're talking about. Thank you very much.
Madam Vice Chair, members of the committee, I'm Kathleen Hope. I'm a professor at the University of Maryland Carey School of Law. We did submit extensive written testimony that discusses some of the undercurrent legal issues that Felicia Langell, my student, testified about. So I won't reiterate those, but we do talk there about the statute pose issue, potential for false claims, and why that should not be a concern here, as well as the fairness of sovereign immunity and the role that plays in our state. I want to address just 2 points and then make a personal comment. First is why criminal prosecution is not enough. And Delegate Wilson spoke to the availability of comprehensive discovery during the civil process, and he's absolutely right. The other point is that prosecutors exercise discretion in the cases that they bring, and they have massively limited resources. So when they're faced with cases that have occurred in the last 90 days or 2 months or 3 years, maybe they're going to allocate those resources accordingly and not be able to put the resource on the investigation and gathering of evidence to prosecute a case that is decades old. It doesn't mean they don't care. It means they don't have the resources to do that work. So that's another reason criminal prosecution is not. The other issue is, again, relates to statute of repose. It really is not a statute of repose. If you're lawyers and you learned about it to study for the bar exam, come talk to me, because I had to relearn it for this bill as well. The last point I want to make is that I was born in, this is personal, I was born and raised Catholic. I'm a member of the Church of the Nativity. in Lutherville, Maryland. I'm extremely proud of my church and what we accomplish every day. What I've been taught since I was little is that the church is not a building. It is most certainly not a corporation. It is the people. This bill is not opposed by the people that are the church. This bill is supported, and we will always stand whether there is money left or not, because we are the church. Thank you.
Really?
Vice Chair, thank you for coming in to testify and dealing with the remedy and the resources. Would a consideration be that claims for certain, say, 20 years,
Are you talking about if the state were to waive its liability? That's in the proposed amendment, I understand. So right now, the state has protection from liability under the state court claim. And so there's a limitation of when you can file a claim and how much you can cover. I do believe that there are amendments that purport to eliminate sovereign immunity completely with respect to these claims. I haven't had time. I saw them for the first time this morning. My point is, and if you read our written testimony, there's a reason to treat the state and private corporations and nonprofit organizations differently. Sovereign immunity has a strong basis in our law to protect the public fisc and not discourage people from exercising governmental discretion. And that's very different than when we look at a corporate entity or a private entity. So there is a reason to treat the state. Same thing. They're a corporation. I see nothing in the amendments or in this legislation. So me personally, I don't see any reason to cap the damages here. Individuals still have to demonstrate what their civil damages are. And you've heard there's so many people today about what those damages may be. I don't think anyone here thinks $1 or $10 million is going to cure what happened to them, but I don't think we should institute artificial limitations on their recovery.
Thank you, Mr. Chair, Vice Chair, person of the committee. My name is Ken Phelps, Maryland Committee, and my esteemed colleague give you a lot of the facts and figures. I just want to speak underscoring our strong support passage bill as biases. And referring back to testimony by one of the earlier panels, we would really strongly love this Maryland also earning things. As we've heard, healing takes time. And in my role as pastor, take the day relating stories to that came to mind just very quickly. The pedophile scandal first years. An older gentleman in my parish, mid-60s, came in, couldn't even speak. He just went. And as he left, the only thing he would say was, I have an altar boy. Didn't tell me. And this is a gentleman that married his daughter. I prized his, just to see that. That was years ago. As recently as yesterday, a colleague who knew I was coming here to test something at the look was silent, right? And all she could be and say was, healing takes time, but so does justice. And we need to remove every barrier to allow that healing. We need to allow it to take its natural course. We cannot cut off any possible victims of this abuse. We'll have their
New. I'm 70 years old. My name is Frank Schindler. I live in Baltimore. When I was in kindergarten in the fall of 1904, at the age of 5, I was sexually abused by a priest several times a week, approximately 6 months. At that age, the ability to process and understand what is going on around you is limited under any circumstances, much less in circumstances that are painful and traumatic. And this abuse is being perpetrated by an individual you are told is the representative of God on earth and must be listened to and obeyed. To speak out or even acknowledge the abuse is simply unfair. At such times, neurological structures in the brain to shield you from those memories in part by suppressing and fragmenting. But those protective actions themselves influence and distort your life, and there is no deadline or timetable how the brain operates or changes. I first came forward when I was years old. For years, I struggled with the consequences of the abuse, with the guilt and shame of being bad, and the belief that I needed punished. I've had to deal with depression, the feeling that I was not worth much of anything, no matter what I did or what I may have accomplished. I repeatedly questioned my right to life, doing things that ultimately caused me harm. And when years of therapy begin to bear fruit, when you slowly begin to remember, to understand, to come out from under the guilt and shame, you are prevented from speaking your truth by the imposition of a completely arbitrary time limit, a time limit which protects and enables the abuser and allows the Catholic Church to systematically and institutionally abrogate its responsibility to the vulnerable children placed in their care. And then I am blamed for not speaking out earlier, for not doing what was possible for me to do. Once again, I'm told it is my fault, just as I was told when I was 5 years old. And when all else fails, the church reduces the pervasive, institutionalized destruction of lives to simply the cost of doing business. But it's the survivor's cost. There is no statute of limitations on the consequences of sexual abuse. 65 years later, I'm still struggling with those consequences. There should be no statute of limitations on the responsibility of perpetrators and those who protect. When I was a child, I was taught baptism in the Catholic Church placed an indelible mark on your soul. Indelible, no statute of limitations. Unfortunately, in my case and countless others, the marks of membership in the church are destructive and tragic. But even more unfortunately, they are indeed indelible. I ask you to support fairness and justice for a 5-year-old. I ask you to support House Bill 974. Thank you.
My name is Noy Davis. I am a lawyer and the vice president of First Star Institute, a child advocacy organization. I have previously testified before this body as an individual. I'm also a survivor of child sexual abuse. Today, I have the privilege and the honor of giving voice to 2 anonymous survivors. So I give you their words. The first, I blame the Archdiocese of Maryland for stealing the first 20 years of my life. Maskell, their priest, I encountered from the age of 12 till I was 17. Drugged, sex trafficked to police. He threatened to kill my parents. He had guns to my head. I told many sisters, teachers, counselors during my high school years. I reported and filed a charge in 19. The police lost the record. How do you live in this country? They all knew. They protected Maskell. People ask, why did you wait? I told many people for the years, and I have waited for my Congress to stand up with me. Please hold them accountable. Change America to stand up. Protect us, please. The second survivor. From age 6 to 9, I was sexually abused by my Annapolis pediatrician. Whenever I saw him, even for an earache, he always insisted on examining my genitalia with his bare hand. I told my next pediatrician what happened, but he never reported it to police. Instead, he referred me to a therapist who also never reported. Last year, I reported both pediatricians to police. As far as I can tell, nothing has come of their investigation. I've learned recently other patients and medical professionals complained about these doctors during their career, but both continued practicing for another 15 to 20 years after I last saw them. I live with PTSD, depression, and anxiety. I've attempted suicide 3 times and spent at least $67,500 on medical. I urge lawmakers to pass HB 974 and those of us least able to protect ourselves. It is time to shift the burden away from victims and onto institutions. Thank you.
Mr. Chair, Madam Vice Chair, and members of the committee, thank you for allowing me to talk. I'm Laurel Morey, an alumna of the Key School in Annapolis, Maryland. I'd like to speak for 2 friends from Key who can't be here. One of them was gay and dating the science teacher when we were kids. He killed himself 7 years ago. The other was the first boy I really loved. He inspired me to believe in God. He began drinking heavily in high school, then died in a drunk driving accident at 17. We think the math teacher abused him. 10 years ago again, I began asking questions. When I was a kid, most adults at Key knew about the abuse. I have compiled a list of 14 adults involved with the school whom I'm certain knew.
The list includes a current and former teacher, department heads, a deputy head of school, the current head of development, significant donor, missions officer, 2 board members, and the president, one of whom was a medical doctor. 3 board. These institutions have the wealth and power that convinces people to be silent. Early 2018, I gave the police a list of survivors, adults who probably knew, and over 20 alleged abusers. 2 years, and the police haven't brought a single charge. Zilch. Meanwhile, a friend recently saw an abuser where teen girls hang out. Another lives near a school. A year ago, I saw one on West Street. One has worked with kids in Baltimore libraries. Many still teach. 5 are still associated with P. The civil justice system must step in, or their names will never be public. We cannot rely on private institutions. I told Key's investigators about 4 predators from my childhood. Their whitewash report only mentioned 2. They got facts wrong. They outed me as a police informant, a potential risk to me and my family. I told Key School, he didn't. We need to give survivors a chance to tell their stories. We must follow statute of limitation and create a look-back window. Otherwise, children will remain at risk. I hope the truth will stop my friends from dying of substance abuse and suicide, because I'm sick of funerals. I urge the committee to support HB 0974. Please, just do it.
Chair, members of this committee, my name is Kathy Shahanian, and I'm the Public Policy Director of this Maryland, as well as a member of the Maryland Episcopal. Thank you. Yeah. The diocese represents a parish in the state of Maryland, and we have 1,000 parishioners, and we support HB 974. Child abuse is a national each day in America. Average 80 children are born neglected. 5 of them die as a result. In the year 2000, 3 million referrals were made to children's service agencies throughout our country. Almost a third of the investigations result in a finding that the child had been mistreated or faced risk of being mistreated. Sadly, child abuse is a reality in our world and must be acknowledged and understood in order for us to be intentional about solving this. Someone that victimizes a child should not be able to hide behind time. HB 974 is about the right thing for those individuals that are traumatized for sexual abuse in Maryland. A person who is sexually assaulted as a child grows into adulthood and takes too long to report his or her abuse. The abuser escapes civil prosecution. The perpetuator is free to stalking, grooming, and abusing children. HB 974 supports a victim's access to the courthouse, irrespective of when the crime was committed. Current law as written defends and protects. Abolishing the statute of limitations of sex crimes against children will not solve the problem of child abuse overnight in our country, but it will arm our society with a vehicle for our children. The Episcopal Diocese is serious about supporting HB 974, and we respect.
Hi, my name is Vanessa Milio, and I'm the executive director for an organization called No More Stolen Child. And I've spoken to many of you about this and other issues related to childhood sexual abuse. I actually just want to start by saying thank you. And this is an incredibly difficult subject to talk about, to listen to, and I really appreciate all of your willingness to be here, to stay in your seat, pay attention, hear people tell their stories. That is unfortunately not something that they are used to. I also want to thank you for passing this legislation last year. You had the institutional courage to move this out of committee and floor, and the House had the courage to pass the legislation. So I'm sorry that we have to ask you to do that again, but we do. And so I hope that we can count on you to be strong for all of us in passing this bill forward. I want to take a minute and address something that has been flying around the room a little bit, and that's the money, because the money is a big plus. And I want to start by the number of $9 billion. That's the estimated cost in the United States of child sexual abuse. That's not my number. That's the clause that goes beyond counseling and therapy session. It speaks to lost wages. It speaks to health issues. It speaks to long-term impact. It impacts the victim, their spouse, family, co-workers, activity loss. This is not a one person, one and done scenario. This is something that we all address and we all face every single. The second thing I want to talk about is options. We've heard a lot about bankruptcy today and a lot of pieces about that. I want to clarify a little bit. Pennsylvania does not have a look. The Harrisburg Archdiocese chose bankruptcy as an option preemptively. The Boy Scouts of America chose bankruptcy as an option for their organization. Institutions have choices. They can choose bankruptcy protection. They can choose to set trust. They can choose to offer counseling. They can choose to address the issues in the court. Institutions have choices. What you're hearing today is survivors asking you for the same choices. It should be the survivor's choice whether or not they want counseling. It should be the survivor's choice while telling their family is enough. It should be the survivor's choice whether they're brave enough to face a criminal court. It should be the survivor's choice whether or not they're brave enough to face a civil proceeding. We're simply asking you to put the choice back in the hands of survivors for how they heal and they see. Thank you.
Are there questions for this panel? See, thank you all very much. Final panel, favor of the legislation. Mary Corzine, Susan Perrin, Judy Lorenz, Lisa Jordan, Joyce Lombardi. All been in the room so far, so and right there.
My name is Mary Corzine, and I'm here to provide testimony as a survivor of childhood sexual abuse in support of House Bill 974. When I found the courage to come forward at last to tell a teacher, multiple degrees, and a therapist, this is what I heard, and it was devastating. He is sick. It's not his fault. You'll feel better when you forgive him. Vengeance alone belongs to God. At least you weren't raped. Is it any wonder that it takes decades for survivors to come forward when this? I tried several times to tell my parents, but became very overwhelmed and panicked because I wasn't sure what would happen next. I didn't know the words to describe what was happening. I was in 5th grade when I was instructed to sit on the lap of the abuser in a darkened room in an empty house on school property. I thought he had a stick in his pocket, repeatedly poking. He told me to wrap my arms around his neck tightly while he talked to me. When it was over, I flew outside, red-faced and crying, and went to the school bathroom. My uniform was wet with an unidentifiable white substance. I wiped it off and returned to class. This happened several times in the same house on school property and also in the boiler room, where I was placed across the top of a child-sized desk hidden in the. I told the teacher about the abuse, but she never told my parents. My abuser was then moved to a different parish. Later in 1986, I learned an 8th grade boy had suicide after being abused by the same priest. The priest, now laicized at his request, was working as a CYO basketball coach in the same archdiocese. He later pleaded guilty to 4 counts of sodomizing a minor and admitted to sexually abusing 6 other boys more than 50 times in the previous 6 years. A plea deal granted him immunity from prosecution using the other 6 boys. He served 9 months. He is not on the Maryland sex offenders. It's heartbreaking to me that a person can commit repeated, constant, and calculated pedophilia in Maryland and get away with it. He is a perfect example of how abusers will continue to abuse until they are. This bill will help to expose abusers like him and protect children in the future. Today, I'm here for them as well as myself. When victims come forward, perpetrators are and children are safer. Creditors depend on the statute of limitation to be able to continue to practice their compulsion. Institutions further protect abusers when they consistently demonstrate a lack of courage protecting their institution rather than its victims. There is hope for survivors, but without resources, trauma can seem insurmountable. Thank you, and please support House Bill No.
My name is Judy Lorenz, and I am here in favor of HB 974. I'm also married to my hero, who is the last gentleman in panel 2. Yeah, we've been doing this. I've been here too many times testifying before this committee on behalf of victims of child sex abuse. Too many times seeing bills stuffed into drawers, not making it across the street, or passed by the House overwhelmingly only to die in the Senate. SOL legislation getting sneakily transformed into a law regarding statutes proposed rather than statute. Extra deliberation requested last year, knowing the tie-breaking senator deployed to Afghanistan the very next day and would not be present crucial enough. There are concerns over institutions that have filed for bankruptcy and the aftermath of SOL extensions. I was more alarmed to see an article in the Washington Post this week focusing on Cardinal McCarran having paid $1 million to an order of priests whose founder was an abuser. I know of hundreds of survivors who would be far better beneficiaries of these types of funds. I got an email last night as a family support person. This was from a survivor. She said, Judy and David, I am sorry, but I just cannot do it. The last time I testified, it really took a toll. And even worse, I haven't updated about what resulted. I had been in mediation with the Archdiocese of Baltimore for counseling costs. You know, that unlimited thing they talk about, that's a farce. When I met with them, it was right after my testimony last year, and they said they were well aware of who I was. I recounted to them my story, as painful and embarrassing as it was, and gave them the receipts, over $10,000 in counseling payments I had made in the 18 months prior, at $200 an hour with a doctor specialist in adult survivor issues. And this does not include the tens of thousands I had previous 4 years. The Archdiocese offered me of which the attorney would no future visit support, unless, of course, I wanted to go to a priest, an unconscionable insult. They said they're worried too many survivors will come home. I declined any payment from them, accepted nothing, and continued counseling out of my own. If anyone is willing to read this, I'm fine with that. I just cannot do it myself. And that was from Gloria Larkin. As a family support person, I have heard the horrors of family members dealing with their loved ones' addictions, divorces, mental illness, and today, my God, again, every time I come here, I'm more surprised than horrified with what is being said. Because these people are speaking the truth. That's a rare thing in our country today. What is it going to take to make Maryland stand shoulder to shoulder with New York, New Jersey, Delaware, and other states who have already passed this type of legislation? This experience, none of us wants to be here telling our stories over and over, but we will until you have had enough. I appreciate the courage that this body demonstrated last year in passing the bill despite the intensive lobbying which you will get. I respectfully request that you do the same and urge your colleagues in the Senate to do that same. Thank you so much.
Good afternoon. My name is Susan Karen, and I represent Maryland Catholics for Action. We're a coalition of Catholics for lay people, priests, women's religious, and even postulates who support victims' rights related to the clergy sex abuse scandal. Our leadership has abandoned our injured brothers and sisters. Our leaders have not provided the transparency and accountability necessary to ensure that these criminal acts. In my written testimony, I provide references to 2 polls that were done in 2019 on U.S. Catholics. One was in The Economist and one was a Gallup poll. And they said the same thing. 30 to 35% of U.S. Catholics personally questioning whether to remain Catholic because of the scandal and have unfavorable views of our leadership. It's important to know that these polls may actually be underestimating laity concern. This is because most Catholics have no idea what our church institutions are doing behind the scenes in terms of spending money and lobbying resources for bills like the Hidden Voters Act. Our leaders often share their legislative priorities on the pulpit, in bulletins, and flock notes. but I've never heard anybody publicly challenge the HPA, though I've heard privately. As an ally group, we have heard victims share with us the stigmatizing response they have received not being believed, judged, or dismissed, or hearing magnificent statements from the church hierarchy which never materialize into substance use. The cost burden of the crime lies predominantly on the victim, and if it doesn't pass this year, they will continue to pay. Anyone who is Catholic should regard this scandal as an existential issue. We are facing moral bankruptcy. The laity are the treasures of the church. We provide the financial office stories and the hundreds of thousands of hours in charitable work. Our voices should be heard just as much as the brother bishops. I hope that you will support HP 97.
Good afternoon, Mr. Chairman, Madam Vice Chair. I'm Lisa C. Jordan with the Maryland Coalition Against Sexual Assault. Been testifying in favor of bills like this for a decade. We are here this year in favor of House Bill 974. There's really nothing I can say that's going to be more compelling to the voices that you've already. I do want to thank Delegate Wilson and Passion for moving the ball forward. I'd also like to point to Delegate Menace, who sure is on your wall, and thank Delegate Petzold and Senator Kelly and Senator Young, and then Delegate Anthony Brown, and every single one of you for voting last year in favor of this bill. This is something that would eliminate the statute. So these people don't have to continually come back and have the pain telling you their stories over again, only to have the state of Maryland simply fail to do very much. Certainly, you've passed bills in the past that have moved the ball forward, but this is a significant important system. It is fundamental to your responsibilities here as legislators. So for those reasons, and mainly for the reason the survivors and their voices that you've just heard, the Maryland Coalition Against Sexual Assault urges a favorable report on House Bill 9.
Mr. Chair, members of the committee, Joyce Lombardi from the Baltimore Child Abuse Center. I'll only raise one point that hasn't been raised by everyone else that you have heard today. And that is that in the 16 states that have look-back windows, we hear this, and some of your colleagues might be talking about this bankruptcy, floodgate for that in the years information from Child USA shows that in Georgia there were 4 claims after their look-back window. In Delaware there were 1,175, 1,000 of which were against one. And so we know that very few survivors actually want to access the criminal or the civil justice system. Healing takes many forms. All this bill is asking you to do is provide those people access. And then once you're in the courts, then memories. Then they have to deal with the evidence of spade, died. And so this is simply for those few courageous forward. All you're doing is allowing them to complete. Thank you.
Questions? Delegate Cox.
Mr. Chair, a list for the attorney. Under the statute scheme as it is, would the sovereign way.
I understand that there are additional amendments regarding that, and I've not seen those.
No, I haven't seen the amendments, but my understanding is that the bill before you did not address sovereign, and so the bill before you, the amendments did.
And do you understand the idea behind the amendment as with delegates' experience?
We're looking forward to reviewing it, I'm sure, and appreciate your interest and support.
Are there further questions? It's the testimony in favor of the legislature. There are people signed up to testify opposed to this. I will say that here we hear their testimony, it is 5, give
here with us today. 5 or 6 bills. But I just want to put that out there. Committee in opposition, Barry Silverman, Minor Carter.
My name is Minor Carter. I represent the American Property Insurance Association. Probably should have stopped favor with amendments. Our issue is solely insurance. As people have talked about monetary rewards, we all know in many cases that incident or never happened except or that is expanded because of presence of insurance money. And we'd like to work with the committee to resolve.
Would it be clear you're finding us favorable with amendments now?
I should have said that. Let me put it this way. What I was told to come to and do it. By the time I signed up, I realized in my testimony, we're not against the input of the bill. We're against the insurance. By the time I thought about what I was going to do, it was not the first time I went.
Sir, go ahead.
Good afternoon, Mr. Chairman, Vice Chair, members. My name is Kerry Silverman. I'm here today on behalf of the Tort Reform Association, a national organization that represents businesses, associations, and municipalities here in Columbia. I'm a Maryland resident bar. I'm here today to express some concern. And before I get into it, I do want to express appreciation, your consideration of this very difficult issue, all of the people that have testified on this topic, current advocacy here. Our issue is really with precedent of this sense, type of approach that's taken. It's not with extending the statute of limitations to whatever a reasonable level in view of the committee. It's with the approach that's taken. And that is an approach that we haven't seen ever before in Maryland. That's an approach that eliminates the statute of limitations entirely, completely, for a type of civil claim. We have not seen that. It's an approach that revives time-barred claims. That's an approach we're seeing here. And it's concerning to us because it sets a precedent for other types of civil actions. Statutes of limitations may be viewed as arbitrary. They may be viewed as unfair to individuals. And in fact, they are, because they take away a viable claim. But it serves a very important purpose. And that purpose is making sure that judges and juries can decide cases about liability on the best evidence available. They can decide cases involving millions of dollars in damages when there are witnesses that are still around, when there are documents that have been discarded, and to make those types of decisions accordingly. I've monitored this issue and testified in many other states. I'd be happy to answer your questions on whether other states have done it on this issue. But the sum up of it is most states have not taken this advantage many times, and most states have, like Maryland has, twice effectively extended the statute of limitations to a finite.
Delegate Fisher, further questions?
To the gentleman who just spoke in the court bar.
In tort reform.
Thank you, Mayor. Court report. I think it would be fair to say, though, that even though this would be a unique precedent in Maryland, that the type of victim in this claim is one of the most class, as it's caring for use children versus any other kind of civil claim that, looking at Maryland, wouldn't be on such a vulnerable and then also of a claim.
It is a special case, but I know in my practice, and I don't represent anyone in this situation, but in my practice, we deal with liability actions. Develop cancer as a result of exposure to a harmful substance many years later. We deal with people who are assaulted, and those are also kind of tort claims, people maimed in the workplace by defective product. The tort law deals with people don't sue for little injuries. They sue for terrible injuries. So there will be cases, and we're already seeing in other states expansions of these types of laws beyond child sexual abuse to other types.
I guess I would say even the examples that you gave, this body and
No one can put the body across our colleagues across the street. But I would say that even in that, it's very different. Product liability issues, they didn't know that was going to harm someone, is not dealing with not only minors, which is such a state interest to protect, and they are dealing with something that is sexual abuse and or rape, which is something that you knowingly know that's going to injure, cause harm, and be detrimental. When I still believe that you can very much distinct this bill for the claim of saying that for civil claims in the future, it's going to be a floodgate up an example that we're going to let dissolve the statute of limitations for other civil claims. I do think that very much, I think all the lawyers on the committee,
Delegates Conaway, Colmes, Griffin.
Test. The first question is, what is the problem? The insurance.
It's a constant problem when you have a step beyond the limitations. And we already have a problem. There's a constant problem of false claims because of the insurance. Because you see the insurance company, you hope they're going to settle to get the claim. And that's a prevalent problem in insurance. Yeah. This would open another false claim.
To the second gentleman that spoke, I think in my mind, it's for me, there's no other precedent on some statute of limitation in Maryland. But what I heard in the testimony, he talked about, say this, the murder of a child soul. Person that there's something that's going to change them. So when you talk about a statute of limitation, this person changed. I don't think there's any limit.
I understand and have a lot of sympathy in this situation. I think in some of the other types of cases talk about, there are people with lifelong injuries, and they could also say will be harmed every day that they wake up for it.
Delegate McComas.
Thank you, Mr. Chair. I'm looking at this a little bit differently because basically the individual doesn't able to put the picture together to realize that they've really been abused until we're saying 52. And so there are different mechanisms within the law where the statute of limitations is told or suspended until the person discovers that they've been abused or not abused, but have been injured. Okay. Or the person, let's say they get hit on the head and they've been unconscious for X years. And then all of a sudden they wake up and they put it all together, and then they would be allowed to sue because they were disabled before. So this isn't quite that unique in that sense because of that. And then I'll finish this and then I wish you to comment. Then you have the situation where you're dealing with a vulnerable class, children, and they might be threatened with a gun, or they say, we're going to kill your pet, we're going to kill your brothers and sisters, we're going to kill your parents if you say anything. So there's this duress. And so they don't have, finally when they 52 and the person's not around anymore, or they realize that they can't kill their parents or things like that, that the light bulb goes on. So in a sense, it's not necessarily really upending the tort system. It's just modifying it for a rather unique situation. So would you comment on it?
Sure. The tort system does have some mechanisms already in place that try to provide extra time for people in circumstances. Obviously, when injury is to a child, the statute of limitations doesn't run an adult at least. There's also, in some cases, a common law discovery rule recognized by the court that give additional time to a person who didn't know they were injured or something, or harmed by malpractice or whatever, and they don't realize until years later they know then the statute of limitations will not start to run until they discover. There's also a positive Maryland law on this, but there's usually tolling for fraudulent concealment in a case where a defendant makes it so that or whoever was injured not know the injury, and if they intentionally do, that would also toll the statute. So there are those types of mechanisms that are already in place here and in other states that are available. They're narrow.
Thank you, Mr. Chairman. As for Mr. Chillerman, following up on Delia McCombs' question, in these cases, so often a child could be 5 or 6 years old, become much older, memory suppressed, they can wear counseling. It could be a young child that's nonverbal. They get older, they get verbal, they discuss it. If you're saying there's mechanisms in place to protect these individuals, I guess what is the harm in then allowing this to be codified to open that window up for people that either needed to build the courage up, finally realize what happened to them, and so on and so forth, to get them the justice they deserve?
Patrick's position on this is just that any statute is finite, not unlimited. And so there was a number, was a higher number. I don't think that. And the second is that changes in statute limitation shouldn't apply. Because when that happens, organizations are judged today based on standards of what we now expect, rather than was known at the time. They may not have purchased insurance at that time to cover the claims that they're now going to face. They may not have saved the records of that long ago because they didn't realize they could possibly be subject to suit years later. And they may not even know if they had him. Find it. So that's concerned with the retroactive. In terms of having more time, I don't think ACTA would have any issue with having a longer period of time, discovery, codified, doing it finite.
Question for you.
Delia Watson.
Thank you, Mr. Chair. I am one of the few members of this committee who has not, so I appreciate all the words. But my question is, I've heard gentlemen talk about traumas. But what really struck me is that one of the ladies who testified said they tried to do suicide. So my question, being an attorney, if she would have been successful in committing suicide, would her family then been able to sue for the murder? Since murder does not have a statute of limitation.
Family wouldn't be process. They would be able to, they might be able to sue for a wrong. I believe the statute of limitations is Maryland on a wrongful death is 5 and 3 years.
So it would take a really skilled attorney to be able to link that suicide directly to the trauma inflicted on that person, possibly 30 years early.
Thank you, Mr. Chairman. Panelists. Real quickly, I think one of you mentioned the best evidence rule, and that would be one of your concerns. Would you be supportive of a limitation, not a statute proposed, but a limitation that would say chance the life and being of the perpetrator, plus a set amount of time after, so like 20 years, so in a reasonable amount of time to be able to obtain evidence that may be readily available?
You said that the lifetime of the perpetrator has
Correct.
a statute of limitations.
Correct.
That's an interesting approach. It's not one that I've seen or considered, that actors considered. It does establish a time frame, and it does at least manage to have a witness there, perpetrator call and trial. So it would be something we'd have to consider, or a position that could express on it, but it does appear to provide a limit.
Further questions from the panel? Seeing. Thank you all very much. That concludes the testimony on House Bill 974.